Hey, Sarah, welcome to the MindShift podcast. How you doing today?
I'm good. How are you?
I'm doing fantastic. Glad you could join me today. Where are you joining us from?
I'm in Las Vegas, Nevada. I think that's where you are as well.
That's exactly where I'm at. um, I'm so glad to have you here. I want to have a conversation about probate and estate planning and wills and trusts and all of those things that you do. But before we dive into all of that, what got you started and interested in law in the first place?
What got me interested in law? Well, to be honest, and this is a very honest answer, I went to college and I got a double major in art history and classical history and didn't know what I was going to do with that because there isn't much to do except maybe keep going and become a professor in one of those topics, which I did not want to do. So that's why I chose law school. That was just like the only thing I could think of that I could do with my degree.
Hmm, gotcha. You've been practicing law now for 20 years. Do you still love it?
I do love it now. I do love it now because I have my own practice and I'm doing what I love, which is exactly what you said, the estate planning and the probate. Those are my favorite areas of practice. And so I really enjoy helping people in those areas.
What is it about those two areas that give you such joy today?
It's kind of a sense of fulfillment. Like it fulfills me because I'm helping people. A lot of times in law, most of the practice areas, people are fighting. But when you're talking about estate planning, that there shouldn't be any fight in that. That's just to help the client prepare for the future and protect their assets. And then with probate, there can be contested probate, but it's not as common as just simply helping the family go through the process, the court system, in order to get the loved one's assets transferred to them. So it to me, it's nice because I get to help people and I feel more fulfilled at the end of the day than I used to when I did more litigation and I with people fighting all the time.
Mm, that makes sense. That makes sense. When did you start your practice? I
I
mean, when did you
start
start as an entrepreneur, should I say, when you broke away from, working for someone and becoming an entrepreneur for yourself?
8 years ago. So, well, you know what? Probably 9 years ago, because my firm has gone through kind of two rebrands. So I would say about 9 years ago, I went on my own, and I've been here ever since, and I couldn't be happier.
Gotcha. You do a lot of public speaking in the world of real estate. You've got a lot of practice areas that you've done in the past. And I know that you're always speaking and doing presentations in the community. And I know one of them centers around estate planning and planning for your future. And I want to talk though about the one that seems to be uh, one of your primary focuses, and that's probate. And there's a lot of uh, misunderstandings about probate, what it is, what it does. And so I want to kind of start with this part of our discussion around understanding what really probate is, specifically in Nevada, where you practice. And can we just start with the basic definition? Like, what is probate?
Sure. Yeah, no, I think that that's a good place to start. So probate is technically the court process of transferring a deceased person's assets to the rightful heirs. So a lot of people don't realize when someone passes away, unless they have the right estate plan, or I shouldn't say right, but a particular kind of estate plan in place, they're probably going to have to go to court to handle the deceased's assets. It's not just automatically going to go to the next in line. You actually have to go to court to get the things transferred. So that's what probate is.
I've noticed from our interactions that probate has different levels to it. And I believe you've told me that it has to do with the dollar value of the estate. Can you share that with the audience a little bit about how that works?
Sure. In Nevada, there's different levels of probate, so different levels of the court process that you might go through, it all depends on the value of the estate. So the way we figure out the value, so we know what level we're going to be in or we fall under, is we've got to take assets minus debts. And the easiest example of that is a home. So a lot of people, their major asset is their personal residence where they live. And so what I will a lot of times ask someone when they're calling in as a potential client and someone has passed away, I'm asking, what are the major assets? Maybe there's only a home. That's the only thing the person had. So we take the fair market value of the home on the date of death. You can use Zillow, just do a quick, what is the home worth? And then we subtract the mortgage if there's a mortgage. So if there's a $500,000 home and the mortgage is $250,000, then we know the value of the estate is $250,000, and then we look at what level we'll be in. So I don't know how far we want to take this, but in that example, we would be in what's called summary administration, which is for all estates that are valued between 100 and 300,000. It's actually the most common one to be in. That's where a lot of estates are valued and where they fall.
And what happens when there's very little to no value in the estate? Do they still need you as an attorney to work through that process?
Possibly not. So in Nevada, if the person who passes estate is valued at $25,000 or under with no real property, then you can do what's called an affidavit of entitlement. You don't need to go to court. You don't need a lawyer. You can just fill out this affidavit that you can find online. There's a nice self-help center at the district court's website that has the form. And then you can take that, for example, a lot of times that's used when someone passes away and they just have a bank account with a couple $1,000s in it. So the rightful heir, the person that's supposed to get the money, can fill out the affidavit, take it down to the bank and get the money.
What causes a contest, or what causes a probate to become litigious, if you will? I've happened to have a couple of scenarios in the back of my mind, friends and or family, and things didn't go quite that smooth, and there were some challenges. What tends to cause a litigious situation or a contested situation? Is that what you call it, a contested?
Yeah, contested probate.
Yeah, talk a little bit about that. What causes that?
I think the most typical one is when someone creates a will and one of the family members or one or more say, no, this will isn't valid because they weren't in their right mind when it was executed. So, they had Alzheimer's or they just had dementia and they didn't know what they were doing. So then they're trying to invalidate the will, probably because they want the money and they're not in the will. But, something like that. That's what I see most typically when we're talking about contests. It's will contests. Because the statute is very clear. If you do not have any estate plan in place and you pass away, then the court simply looks at Nevada law to determine who gets your stuff. So there's really no argument there. It's just you literally look at the law, and it's generally speaking the closest blood relative or relatives will get it. So it's hard to contest in that when there's no will. But if there's a will, maybe there's a problem with the will. Maybe they're contesting. I've had this where it's a holographic will in Nevada. They are valid. So holographic wills are wills that are entirely written in the testator's, the decedent's own handwriting. There's certain requirements for them to be valid, but obviously these people they did not go to a lawyer or they wouldn't have a holographic will. So the other way to contest is to say, okay, this isn't the decedent's handwriting. They did not sign this. It's not them. And if, of course, that's happened. But those are the two most common ways to contest in probate.
What is the take someone listening through it? I mean, I know you handle this all day, but our listening audience may or may not. Someone in their family passes away and they're the closest relative, let's say, to that person. And they go to the bank and try to access their father's account, let's say, or their mom's account or what have you. How does someone know that they need probate? Is it when they go to the bank and they realize, oh, by the way, you can't get access to the bank account? Like, how does someone know they actually need probate?
Yeah, that's a great question, because I think a lot of people that call me, they're calling me because they finally realize they need it. Sometimes it's literally 10 years later, believe it or not. Or, it can be months later, it can be the next day. It just depends on what assets we're talking about. But for example, with respect to the bank situation, if someone, okay, your family member passes away, they have a checking account. There's no death beneficiary on the account. So you go down with the death certificate to the bank and say, hey, how do I get this money? Again, if it's under 25,000 in that account, then you're going to use that affidavit of entitlement. The bank generally knows about those, so they'll give you some general information to go search for it for this form. But if the value is over 25,000, then they're going to just tell you got to go to probate, and then that's all they're going to tell you. So then that's, I think, when people start Googling probate attorney and give us a call and say, what do I do? But when I talked about the 10-year example, comes up a lot, believe it or not, with real property, because someone passes away, they have a house, their kid's already living with them. Let's say it's a single mom, their only son is living in the property. Mom passes away, he keeps paying the mortgage, right? Doesn't change a thing, doesn't even tell the mortgage company. So he's just paying it. Mortgage company doesn't care because they're getting their money. And then all of a sudden, 10 years later, he's like, okay, I'm ready to move on. I want to sell the property and get a new property. And then some people will literally not realize it until they hire a realtor. The realtor looks at the chain of title and realizes it's not in his name. And then he calls the lawyer and says, hey, wait a minute, I got to get title transferred to me so I can sell the property. So sometimes it really does take that long. But most of the time, like you said, it's just all of a sudden they're trying to access an asset and they can't. And most of the people they're talking to for that asset are just going to say, oh, call a lawyer, because they're not allowed to say anything else. So it's just when they find out they can't get the money or the asset, then they call the lawyer.
Of course, we can't get
Yeah.
to what we need. How long does the process take in Nevada?
Depends on what level we're in. So if we have there's different levels. I don't know how detailed you want me to get, but just generally, there's the affidavit of entitlement, which is 25,000 and under. Then there's something called a set aside estate, which is for anything 100,000 or under, meaning the value of the estate, and it can include real property. So in that case, that takes about 3 months right now to get through. It's just one court appearance, so that's why it doesn't take as long as the others. And then the next level is the summary administration that I mentioned before, that's for estates valued between 100 and 300,000. That is taking, it's taking 6 to 9 months generally right now to get through. And there's some factors that affect that. If you have a home you need to sell, in the probate process, it might take a little bit longer, not much, but generally 6 to 9 months. And then the next level up is general administration. It's for all estates over 300,000, and that usually takes 9 months to a year, give or take, sometimes longer, depending on how much money we're talking about. The higher value estates, they just take longer to get through in general.
Mm. So that if I would imagine you don't work for free, so
Right.
what are the costs associated with probate, and who pays those?
Great question. So technically speaking, we represent the estate, and whoever is the administrator or the personal representative. So we should get paid out of the estate. Normally we get paid out of the estate at the end. So the heirs have no upfront costs. It's zero down. The court has to approve our fees on the final order. So we submit our fees and the court approves them, and we get paid out of the estate assets themselves. There are situations where we don't get paid out of the estate. The heirs have to pay us up front. That's when there's no liquid assets to pay us out of the estate. So perfect example that happens a lot is the home thing, again, with the home. If someone, especially I just had one where it was a married couple, title was in the husband's name, husband passed away, wife of course wants to keep the property and stay in it. So we had to go through probate, unfortunately, to get title transferred to her. So she paid me up front, and because of course there wasn't going to be any value with the estate, and that's how we did it. But normally we get paid at the end through the estate.
Gotcha. So we've covered this. There was one other question. You said earlier, if someone has a will or doesn't have a will, is there a distinction about whether probate can be avoided if someone does have a will it still have to go to probate? I don't know if I missed that.
Yeah, so if someone does have a will, likely it's still going to probate. That's not going to prevent probate. But if they have a trust and everything's already in the trust when they die, which it should be, then they can avoid probate altogether. So a will doesn't avoid it, but a trust does. And the reason to have a will, at least, is to tell the court who gets your stuff versus the court looking at Nevada law.
And that actually leads me, because I was thinking, what's the better plan for most people than to have the court obviously take 3 months to 6 to 9 months to 9 to 12 months to organize and figure all of this out? What's a better path for most people? And I know that's the other side of your legal practice. And so let's kind of transition to that.
Okay. Yeah, that's a great segue. So to avoid all of this, the thing to do is generally, and again, I'm just speaking in general terms. I'm the lawyer, so I got to put the disclaimers. Generally, you would want a trust. And the most popular kind of trust is called a living trust. And the reason it's so popular is because when you're alive, you have complete control of it. Nothing changes for you. You can do whatever you want. It's like you own the stuff, but you don't, because you're putting it in the trust. And then the trust is the owner, but you're the manager of the trust, so you get to make all the decisions. As long as you do that and everything is in that trust when you pass, then your family will not have to go to court at all in order to transfer the assets to the right heirs.
You said something to me, I don't know, 6, 8 months ago. It actually became one of your most popular videos on Facebook, as a matter of fact. And you said, anyone, if you have a spouse, a house, and 2 kids, you need a trust. And I asked you the question, like, aren't trusts just for rich people or people that are affluent or have a lot of money? And tell our audience what your thoughts were on that, because I thought it was very, very intriguing.
Absolutely not. So trust is for the normal person, right? Just anyone that has some assets like a house. That's why I said a house, because that's usually a pretty big asset. Whether you have a mortgage or not, it's a main asset for most people. So you absolutely should consider a trust if you have a house. Also, if you do have children, because you want to make sure it's passed down to your children and they don't have to go to court to get it. And then also, of course, if they're minors, making sure there's something in place so that they can have access to the assets through another person, through a trustee, but not get everything all at once when they turn 18. If you want to, that's the other thing trusts are used for, to do sort of sometimes a tiered giving or put rules and restrictions in place so that your 18-year-old son doesn't, get access and buy a Ferrari and, travel around and spend the money. Right. So that's a typical thing we always put in trusts. It's in my trust for my son. He has restrictions.
Gotcha. And so is a trust what they consider to be estate planning, or is there a bigger distinction between, because we hear the word estate planning and then you hear the word trust? Compare and contrast that term estate planning with a trust, and are they the same thing?
Yeah. So a trust is a type of estate plan.
Okay.
And a will is also a type of estate plan too. I mean, having a will is an estate plan. There's also, whenever we do estate planning, whether it's a will or a trust, we always include the incapacity planning. So those are the documents that kick in if you are still alive, so not dead, but incapacitated, and can't make your own decisions. So those include the power of attorney over financial decisions, which is a document that kicks in if you're incapacitated, but you still, of course, need someone to get in your bank account and pay your bills, essentially. So you can nominate someone to do that if that ever happens. And then there's the power of attorney over healthcare, or otherwise called the advance directive, mostly having to do with if you're on life support, making that decision whether to pull the plug, and you provide guidance about that in the document itself. There is part of that document that includes other things such as assisted living facilities, whether you're going to authorize someone to put you in one or not. So there's other components to the healthcare power of attorney. So we always do the incapacity planning in any estate plan, plus either a will or a trust generally. A lot of times, estate planning also has to do with asset protection, because people want to not only pass their assets down to the right people, but they want to protect them along the way. So they want to make sure that they have assets when they die to give to their family. So some of that includes the typical easy example is if you have a house and a spouse and 2 kids and a rental property, then
Oh, the up one.
we would want we would want to we would want to make that rental property not directly part of the trust for liability purposes. There's different kinds of trusts, and I don't want to get too complicated, but the one I'm talking about is the most popular, which is not a liability tool at all. It is just an estate planning tool. So it doesn't protect your assets. It just passes them to who you want. So if we've got a rental property in the equation, then we wouldn't want to put it directly in the trust, because then if there was a problem at the property and a tenant sued, they would sue the trust and all the trust assets would be exposed, which we do not want. So we normally tell them, okay, let's set up an LLC to own the property. And then the owner of the LLC can be the trust itself. So it'll flow through to the trust at the end, but there'll be a liability protection in place before that. So it's not just exposed.
Yeah, I know you work with business owners as well, and you do business. Is that the same? By the way, this is not legal advice, but when you just brought that up, it struck up a point. If someone owns a business, and are you suggesting in general that the ownership of the business exists outside of that living trust as well? Is that, and again, I don't want, if that's taking you down a,
Well, sometimes it depends. Of course, it depends.
okay, it
Favored attorney
depends, right?
answer. But here's the deal. No, I mean, that's a good point. Succession planning in businesses is really important. So when I'm dealing with business owners and we're doing their estate plan, then we, of course, include the succession planning. It might look like making sure your operating agreement, if you have an LLC, has certain clauses in it for succession planning. Or if you're a corporation, your bylaws have the right clauses in there. And or it might look like transferring your actual interest in the business to your trust, just depending on the situation. So
Yeah,
it's
it's
important.
complicated, right? It's all depending on the person and their assets and things of that nature. To kind of wrap up maybe a little bit of the living trust side and the estate planning side, typically when someone's going through their life experiences, I think you identify them as kind of triggering events when it's probably an appropriate time to think about planning, right? No one wants to think about, I think you've told me this in the past, like no one wants to think about the day that they'll leave this earth and they'll leave their friends and their family and their things. But it's something you said, there's like triggering events when it really should pop to mind for you to maybe at a point to take time and think about uh, planning for the transfer of your assets, your estate, your legacy, as you, whatever you might want to call it. Talk to us about those sort of triggering events that you see are good time marks in our life journey.
Marriage is a big one. If you get married, then if you already have an estate plan in place, you're definitely gonna want to relook at it, because Nevada's a community property state, so marriage does change things, and that also goes sort of into the asset protection as well, because most of the time I'm also having a conversation about a prenup or a post-nuptial agreement to protect certain assets, and pass them down to maybe people that aren't your spouse, right? So marriage is a big triggering event. Divorce, on the opposite end, divorce is also a huge triggering event, because if you already have a trust in place with your spouse, according by Nevada law, that trust is no longer valid. Everything in it is community property, should have been
Oh,
dispensed during the divorce, and now we got to restart over and
ooh,
change your estate plan. Having a child, huge trigger, to make sure. Most times, I mean, it happened to me. I'm an estate planning attorney, but when I had the kid, that's when I was like, oh my gosh, I really need to focus on this, because I want to make sure that my son, not he gets the stuff, he gets it at the right time, and I protect all my stuff for him. So a baby is a big trigger. And then if you purchase a home, because like we've been talking about, a home is a huge purchase. It's usually a major asset of someone, and you want to make sure that that asset is not only protected but passed down to the right people. So I think the house, the marriage, divorce, and baby, huge triggering events to really start thinking about estate planning, because now you've got people and assets that matter, and you want
right.
to make sure that those things are protected and passed down the way you want.
Gotcha. Gotcha. You know, there, our audience, I'm sure they're listening, and I, yeah, I appreciate all the details. Could you spend someone listening on the other side of this? And I know it could be anyone, anywhere in the world, but obviously, if you're in Nevada, this is more relevant to you. You have to check with your local attorney in your local market if you're in the United States. But what are some good best practices for really how someone, you just kind of talked about the triggering events, but are there some tips or best practices for someone who they could have done this a while ago and forgot about it, put it in a drawer? Maybe they did a will 20 years ago, put it in a drawer. You talked about a holographic. I'm assuming they wrote it themselves, and you
Right.
know, share some of the best practices or tips, maybe things, mistakes people could avoid if they've maybe thought about this and maybe pushed it away for a while, or maybe they haven't thought about it at all. Like, where would you have someone, the average person, begin?
Well, I guess it depends on if you already have an estate plan. I'll start with, if you have an estate plan already and it's 10 years old, 20 years old, whatever it is, I would just tell you to please look at it and
Yeah.
keep it updated, because the one thing that happens a lot is people don't keep it updated. So then someone will predecease, won't be around anymore. And then all of a sudden, we've got to figure out who's getting it. And there might be two probates without complicating things, depending. So you just want to make sure, if you have an estate plan, you keep it updated and look at it every couple years. I send my clients an email once a year just to kind of trigger them to say, hey, look at your estate plan, make sure it's okay, if everything's the way you want it.
Yeah.
And then if you don't have an estate plan, one of the things I always share with people is some of the tips, like tools that you can do before you even, I know sometimes it seems like very daunting to start a will or deal, like you said, deal with it, because people want to procrastinate that stuff. They don't want to think about their demise. So maybe baby step in could be one easy thing you can do without a lawyer, is just make sure that your financial accounts have death beneficiaries designated on them. So then they will pass outside of probate. Whoever it is won't have to go to probate to get the money. They won't even need to do that affidavit of entitlement. You can do that for personal accounts, not business. So your personal checking account and your personal savings account, you can designate a death beneficiary. I don't know why the banks don't just do this automatically when you set the account up, but they don't. So they make it hard for you. You have to ask them. But I mean, just ask them and get your death beneficiary designated on that level. And then same, of course, with retirement accounts, you should always have beneficiaries designated. And the same thing applies about just making sure you keep it updated, because I've had to do, surprisingly, actually, a lot of probates where unfortunately the the designated beneficiary on an account has predeceased the person that dies. So typical like one example is I had it was the daughter, her mom passed, but her IRAs were actually, the death beneficiary was her husband, her dad, but her dad had predeceased by like 5 years. So unfortunately, her mother hadn't updated the account to have her daughter the beneficiary. So we had to probate, even though the mom had a will. She actually had a will. She thought she was doing the right thing, but she didn't catch that account. So that's why it's just really important to keep everything updated as you go through life.
You didn't say it, but I'm going to call it out and you can tell me if I'm right or not. is probate more expensive than doing this planning on the front end? Because it, it sounds like it all gets worked out in the end. But what's better for the person listening? Is it better to plan ahead, or and from a cost standpoint? We
Right.
just got to cover that. We got to tackle that because we
Yeah,
haven't
no, no,
covered it,
you're
because it sounds like it all gets handled. But what's better
right.
for the person listening?
Estate plan all the way. You're going to pay, I don't know. I mean, it depends on the value of the estate, but you're paying nothing for the estate plan versus what you would pay a lawyer to go through probate. A huge difference in costs. I mean, the
Okay.
average estate plan for an individual, let's say, would be my firm. If you're doing an individual trust with the incapacity planning documents and all of that, I don't have any problem saying it averages around $2,000, right? So, but if I'm doing probate for the same person and we're in summary administration, we're probably spending $7,500 to $10,000 to get through it. So
Whoa,
huge
4 or 5
difference.
times? Oh my
Yeah,
geez.
a huge difference. So if you,
Wow.
it really pays to plan ahead in this situation.
Wow. Oh my geez. That's a huge distinction. I didn't know it was that big of a gap.
Yeah.
So, and I wanted to do that because I wasn't sure. And it sounded like it's going to get worked out. Just one's going to take time. But obviously, there's a cost to that time as well, obviously, because they're going to need an attorney. And um,
Yeah.
that's good. Thank you for sharing that. So, if you're listening and if you're listening here in Nevada and you don't have your planning in place, I think you're going to want to reach out to Sarah. Sarah, where can people connect with you here in the Nevada area? You're specifically in Las Vegas, but if someone's listening here in Vegas, which we definitely have a good audience here because that's where I'm based, where can people find you?
You guys, well, anyone can go to our website and click on contact us now, and they'll get they'll see my calendar and they can book a free 15-minute phone call directly on the website, or of course they can just call our office and schedule it from there. I don't know if I need to say my website's name or if it's ocampowisemanlaw.com is the website. So it's super easy to make an appointment if you want to. And like I said, we do complimentary phone consults.
Awesome. Well, Sarah, thank you for all of your years of experience and sharing some of that with our audience today. Um, I know that the business has gone through two rebrands. You said I know it went through a name change last year, and you're still driving the ship and driving the engine. So I appreciate all your work and helping. Really, in the big picture, you didn't say it, but you're really helping people protect their their finances. You're helping them protect their
Yeah.
interest and what they really wanted to have happen. Uh, Take our listening audience out with any final thoughts that you have around this topic of estate planning or probate.
Thanks, Darrell, and thank you for having me on here. I think you touched on everything, but the highlights are the most common misconceptions about all this is that, like you said, it's for rich people. It's not for rich people. It's for anyone that has anything that they think is valuable, like a house, right? Or just some money in the bank or something. And they want to make sure it gets to their family. That's what it's for. And it's not as daunting as you think. Once you hire the lawyer, we're going to go through the whole thing and make it easy. And then, like I said, at least if you do nothing after this podcast, get your financial beneficiary designations in order at a minimum. That'll really help your family. Most people do this. The reason to do estate planning for most people, the driving force, is simply to help the people they leave behind, because once you're gone, they're already hopefully going to be grieving and it's going to be a hard time for them. And the least that people want to do is give the gift of, okay, here, this is going to be so easy. This is who gets what, and this is how you get it, and it's all done, and we don't have to worry about it. So again, thank you for having me on here.
Awesome, Sarah. Thank you so much for sharing. And listening audience, I hope you got some great value and some great tips out of listening today to the MindShift podcast. Sarah Ocampo is based here in Las Vegas, Nevada, and we're going to link up her website as well as her calendar link inside of our show notes. So wherever you're listening to the podcast right now, you can just look at the description and be able to click and go visit her website and take her up if you're here in the Nevada area on that free 15-minute consultation. For the rest of you, thank you so much for hanging out with us today. If you have not done so already, hit the follow or subscribe button wherever you're listening so that you never miss an episode. And if you're not a part of the MindShift community, I'd invite you to head over to mindshiftcommunity.com where we can keep you updated on all of what's happening inside of the world of MindShift. And until next time, I'm your host, Darrell Evans. Take care. hit the subscribe button so you can become a part of the MindShift community. We'll help you shift your mind so you can shift your results.